By the time the arrest was made, the investigation had been running for 14 months. That duration was not in itself unusual for a case of this complexity. Serious criminal investigations involving multiple jurisdictions, extensive forensic analysis, and a substantial witness pool routinely extend across comparable timelines. What was unusual by the 14th month was the accumulated weight of institutional expectation that had formed around the case, and was now pressing with increasing directness on the decisions of the people responsible for resolving it. The pressure had not arrived suddenly. It had built incrementally in the way that pressure on long investigations tends to build, through the quarterly reviews in which senior officials asked for progress assessments and received updates that were accurate but unsatisfying, through the media cycles that returned to the case at intervals and framed each return as evidence of institutional inadequacy, through the internal communications in which the language of urgency had gradually displaced the language of methodical inquiry. By the end of the first year, the investigation was being described in the vocabulary of the agencies conducting it, not as ongoing but as approaching resolution. The distinction mattered. Ongoing investigations have indefinite timelines. Investigations approaching resolution have destinations. The case had opened with the discovery of circumstances that required immediate and sustained investigative response. The initial phase had proceeded with the intensity that serious cases produce at the outset. The rapid assembly of evidence, the coordination between agencies, the deployment of resources at a scale that signals institutional commitment. In those early weeks, the investigation had moved quickly, and the movement had generated internal confidence that the case would resolve within a reasonable period. That confidence had not been entirely misplaced. The early investigative work had produced a substantial body of evidence, physical, documentary, and testimonial, that established the basic parameters of what had occurred. What it had not produced, by the end of the initial phase, was a finding sufficiently consolidated to support charges. The evidence pointed in directions. It did not yet point, with the clarity that prosecution requires, at a person. The middle period of the investigation, the months between the initial intensive phase and the eventual arrest, was characterized by the particular difficulty that complex cases encounter when the early momentum has been exhausted and the remaining work is the slower, more painstaking work of closing evidentiary gaps. Leads were pursued and assessed. Some produced material that advanced the picture, others consumed resources without generating return. The investigative team worked through the list of persons of interest that the early evidence had identified, applying the available tools to each, narrowing the field through a process of elimination and accumulation that is, from the outside, difficult to distinguish from stagnation. From the inside, it did not feel like stagnation. Investigators who work extended cases develop a relationship with the evidentiary record that is qualitatively different from the relationship that outside observers, including senior officials, oversight bodies, and the public, are able to form. They know which leads have been genuinely exhausted and which remain open. They understand the significance of incremental findings that do not, individually, constitute breakthroughs, but that collectively advance the picture. They maintain, across months of sustained work, an operational sense of where the case stands that is more granular and more accurate than anything that can be communicated in a briefing document. What they cannot fully communicate in those briefing documents is the nature of the remaining distance between where the investigation stands and where it needs to be to support a charge. That distance, the gap between a well-developed evidentiary picture and a prosecutable case, is real, and it requires continued work to close. but it does not translate easily into the language of institutional progress reporting, which tends to measure advancement in visible outputs: arrests made, charges filed, cases closed. The sustained, careful work of closing evidentiary gaps does not produce visible outputs at regular intervals. It produces at some point a case that is ready, but the readiness arrives as a conclusion rather than as a series of measurable milestones. The institutional environment in which the investigation was operating had limited tolerance for this dynamic. The agencies involved were accountable to oversight structures that required regular demonstration of progress, and progress in those structures was most legibly demonstrated by movement toward resolution. The senior officials who bore responsibility for the agencies were, in turn, accountable to political and public audiences whose attention to the case had not diminished with time. If anything, the passage of months without a visible outcome had intensified the scrutiny applied to the investigation, had produced a narrative, in some quarters, of institutional failure that the agencies were motivated to displace. An arrest would displace it. Not because an arrest constitutes resolution. Investigators understood the distinction between an arrest and a conviction, between a charge and a proven case, but because an arrest is a visible institutional act that signals, to the audiences that matter to institutional accountability, that the investigation has produced a result. It transforms the public narrative from one of ongoing inquiry to one of imminent accountability. It demonstrates that the resources committed to the case have not been committed in vain. This dynamic does not require anyone to make an explicit decision to arrest before the case is fully ready. It operates through the way institutional pressure shapes the threshold at which readiness is assessed, through the gradual recalibration of what counts as sufficient, what counts as close enough, what level of evidentiary consolidation is adequate to support the step that the institutional environment is waiting for. By the 14th month, the investigative team had assembled a case that its senior members assessed as strong. The assessment was genuine and professionally grounded. The evidence that had accumulated across the investigation, taken as a whole, presented a picture that pointed consistently toward the individual who was about to be charged. The gaps that remained, the questions that had not been fully resolved, the alternative explanations that had been assessed as insufficiently supported but not formally eliminated, were judged to be within the range that prosecution could manage. They were not nothing. They were the residual uncertainty that complex cases always carry, and that the adversarial process, in the assessment of the investigators and prosecutors involved, was equipped to address. The arrest was made on a Tuesday morning. The operational details were managed with the precision that the agencies involved brought to this category of action. The suspect was taken without incident. The charging documents were filed. The case number, which had been open for 14 months, was now associated with a named defendant. Inside the agencies, the response was the particular form of relief that extended investigations produce when they reach their first visible milestone. The work was not over. Everyone involved understood that the work was not over. But a phase had concluded. The investigation had delivered what investigations are ultimately expected to deliver. It had found someone. The case had its ending. What remained to be determined in the courtroom, in the record, in the slow evaluation of everything the 14 months had produced, was whether the ending was also the truth. Every investigation reaches a point at which it must narrow. The early phase of a serious criminal inquiry is necessarily expansive. It casts wide, follows multiple lines simultaneously, treats the evidentiary landscape as open terrain requiring exploration in all available directions. That expansiveness is appropriate and necessary. It is also, by definition, temporary. Investigations that do not narrow do not conclude. The discipline of criminal investigation is, in significant part, the discipline of narrowing responsibly, of moving from the broad initial field to the specific finding that prosecution requires, while ensuring that the narrowing is driven by evidence rather than by the operational convenience of having a smaller problem to manage. In this case, the narrowing had begun in the investigation's middle period, approximately 7 months before the arrest. It had begun, as narrowing typically does, for reasons that were defensible at the time, reasons grounded in the evidentiary record as it then stood, in the professional assessments of experienced investigators, in the resource realities of a case that had already consumed substantial institutional capacity. What distinguished the narrowing in this case from the responsible narrowing that investigations require was not its timing or its logic considered in isolation. It was what it closed off, and the degree to which what it closed off was allowed to remain closed as the case developed toward its conclusion. At the 7-month mark, the investigation had developed 3 principal lines of inquiry, each associated with a distinct evidentiary thread and a distinct set of persons of interest. The first line was the most developed, supported by the largest body of evidence and the most direct connection to the central facts of the case. The second was less developed, but had produced in the preceding weeks findings that investigators assessed as significant enough to warrant continued attention. The third had been active since the early phase of the investigation, but had not generated the kind of material return that would justify sustained resource allocation indefinitely. The decision to concentrate resources on the first line, reduce investment in the second, and formally close the third was made through the ordinary supervisory processes of the investigation, reviewed by senior investigators, documented in the case management records, assessed as consistent with the evidentiary picture as it then stood. It was not a dramatic decision. It was an allocation decision of the kind that complex investigations require regularly, and it was made by people with the professional authority and the contextual knowledge to make it. What the decision assumed, and what the evidentiary record at that stage arguably supported, though not without qualification, was that the first line of inquiry was sufficiently more promising than the alternatives to justify the concentration it was receiving. The assessment was reasonable. It was also, in retrospect, made at a point in the investigation when the full implications of the material the second line had recently produced had not been thoroughly evaluated. The findings were noted. They were included in the record. They were assessed as interesting but not, on balance, sufficient to redirect the investigation's primary focus. The evidentiary ambiguities that existed within the first line of inquiry, the elements of the record that admitted of more than one interpretation, the witness accounts that were not fully consistent with each other or with the physical evidence, the forensic findings whose significance depended on analytical assumptions that had not been independently validated, were addressed through a process of interpretation that, examined in sequence, shows a consistent directional tendency. Ambiguous evidence was interpreted in the reading that supported the developing hypothesis. This is not a neutral observation. It describes a specific pattern, and the pattern has significance, but it is also not, in itself, evidence of bad faith. The interpretation of ambiguous evidence always occurs within a framework, and the framework that investigators bring to that interpretation is necessarily shaped by the totality of what the investigation has produced. When the totality points in a direction, the interpretation of ambiguous elements in that direction is not unreasonable. It is, cognitively and professionally, the path of least resistance. The problem is that the path of least resistance and the path of greatest accuracy are not always the same path. In a case where the central hypothesis has accumulated institutional momentum, where it has been adopted as the working framework by experienced investigators, reviewed and affirmed by supervisors, and communicated upward through the agency hierarchy as the basis for the approaching resolution, the interpretation of ambiguous evidence in the direction of that hypothesis is not a neutral act. It is an act that incrementally consolidates the hypothesis against challenge, that reduces the effective evidentiary space available to alternative explanations, that makes the eventual finding feel more inevitable than the underlying evidence considered without the hypothesis would support. Defense counsel, engaged following the arrest, identified several of the ambiguities in the record and pursued them through the available procedural channels. The pursuits were documented. They received the responses that the system provides: rulings on admissibility, determinations of relevance, assessments of whether the concerns raised met the applicable legal standards for the relief requested. What the responses did not provide, in most instances, was a substantive engagement with the underlying evidentiary questions that the defense had raised. The procedural framework through which those questions were addressed is not designed for substantive engagement. It is designed to determine whether specific legal thresholds have been met, whether evidence is admissible, whether requests are timely, whether the grounds asserted support the remedy sought. The threshold determinations were made. The underlying questions remained, in the record, unanswered in any deeper sense. Within the agencies, concerns raised at lower levels of the investigative hierarchy about the adequacy of the inquiry into the second line of evidence, concerns that had been present in documented form since the resource reallocation decision, had not generated the reconsideration that their authors had, in some cases, expected. The concerns were in the file. They had been noted by supervisors. The supervisors had assessed them against the totality of the evidentiary picture and had concluded that they did not warrant revision of the investigative strategy. The conclusions were professionally defensible. They were also conclusions that the institutional momentum of the case made substantially easier to reach than their opposites would have been. Uncertainty, in the operational vocabulary of an investigation that has been running for over a year and is approaching the point of charge, is not a neutral condition. It is a problem, specifically a problem of timing and resource and institutional credibility. Every unresolved question is a potential vulnerability in the case that prosecution will have to manage. Every alternative explanation that has not been formally eliminated is a thread that defense counsel will pull. The operational incentive for investigators and prosecutors working toward the filing of charges is to reduce the number of open questions to the minimum that the evidence will support, to achieve, before the case reaches the courtroom, the degree of evidentiary consolidation that makes the prosecution's position as defensible as possible. This incentive is not illegitimate. It is part of the professional responsibility of preparing a case for trial. The difficulty is that the process of reducing open questions is not always the same as the process of answering them. Questions can be reduced by being answered, by the development of evidence that resolves the ambiguity in a documented and verifiable way. They can also be reduced by being assessed as insufficiently significant to require further pursuit, a determination that closes the question for institutional purposes without resolving it in any deeper sense. By the time the charges were filed, the case that the prosecution held was coherent, documented, and directed. It moved from evidence to conclusion along a path that had been cleared over 14 months of most of the obstructions that had initially complicated it. What had been cleared away, and what had been genuinely resolved were not precisely the same set of things. The distinction was in the record for those who would eventually read it with that question in mind. The path was clear. The clearing had been thorough, but thorough and complete are different conditions, and the difference at that moment belonged entirely to the future. The moment of imprisonment is, in the operational vocabulary of criminal justice institutions, a moment of completion. It is the point at which the sequence that began with the opening of an investigation, the assembly of evidence, the identification of a suspect, the filing of charges, the conduct of a trial, the delivery of a verdict, reaches its terminal output. A person has been deprived of liberty by the authorized action of the state, pursuant to a finding made through the procedures that the state has established for that purpose. The machinery has run its full course. The case has produced its result. This framing of imprisonment as completion is not incidental to the way justice systems function. It is structural. The entire architecture of criminal procedure is oriented toward this endpoint. The rules of evidence, the standards of proof, the adversarial format of trial, the appellate mechanisms that review the process before it finalizes, all of it is organized around the production of a determination that is, once made and confirmed, sufficient to justify the deprivation of liberty. Imprisonment is not a byproduct of the process. It is its purpose. The process exists to determine whether imprisonment is warranted, and when it determines that it is, the imprisonment is the completion of the process rather than a consequence of it. What this means practically is that the institutional systems involved in producing a conviction do not experience the resulting imprisonment as an ongoing responsibility. They experience it as a conclusion. The investigation is closed. The prosecution is complete. The court has adjudicated. The correctional system has received its charge. Each institution has discharged its function and transferred responsibility to the next. The chain of institutional handoffs terminates in the correctional facility, and the correctional facility's function is administration rather than evaluation. The question of whether the imprisonment is warranted has been answered by the institutions upstream. The facility downstream administers the answer. The investigation that had consumed 14 months of institutional resource and attention did not formally close with the arrest. It closed in the operational sense that matters to the agencies that conducted it, with the conviction. The arrest had been the first visible milestone, the point at which the external narrative shifted from ongoing inquiry to imminent accountability. The conviction was the second and final milestone, the point at which the institutional investment in the case was validated by the outcome it had been working toward. Validated is a precise word here. The conviction does not merely conclude the investigation. It retroactively confirms the adequacy of the investigation, confirms, through the operation of the legal process, that the evidentiary work done over 14 months was sufficient to support the finding that the investigation had been building toward. A conviction is, among other things, an institutional certification. It certifies that the case was real, that the evidence was sound, that the judgment of the investigators and prosecutors who developed and presented it was correct. This certification function is part of what makes post-conviction doubt so institutionally uncomfortable. A finding that the conviction was wrong is not merely a finding about the defendant. It is a finding about the investigation, about the adequacy of the 14 months of work, the soundness of the evidentiary assessments, the validity of the decisions that narrowed the inquiry and directed its resources. It is a finding that the institutional investment produced a defective output. The organizations that produced it are not, in general, structurally motivated to make that finding about themselves or to facilitate its being made by others. The restoration of order that a conviction produces operates simultaneously at several levels. At the community level, the conviction answers the question that the original crime opened. Something serious happened. It has been investigated. A responsible party has been identified and subjected to consequence. The social disruption produced by the crime, the uncertainty, the anxiety, the demand for accountability, has been addressed through the authorized channels. The authorized channels have produced an authorized answer. The community's expectation that the state would respond to the harm has been met. At the institutional level, the conviction produces a different but related form of restoration. The agencies that committed resources to the investigation can close the file with their investment confirmed. The prosecutorial office that developed the case can record the outcome in its institutional documentation without the notation that represents failure. The court that adjudicated the matter has fulfilled its function. The correctional system has received a new admission consistent with its operational mandate. Each institution has performed its designated role and produced a result consistent with its designated purpose. At the political level, the level of accountability that elected and appointed officials face for the performance of the agencies under their authority, the conviction produces the most directly legible form of resolution. The case that had been open, that had attracted scrutiny, that had been cited in oversight hearings and media coverage as evidence of institutional inadequacy, is now closed. The closure is documented and public. The officials responsible for the agencies involved can point to the outcome as evidence that the institutions performed. None of this requires that anyone involved consciously prioritize the restoration of order over the accuracy of the finding. The people who investigated, prosecuted, and adjudicated the case were, by all available evidence, people who believed in the accuracy of what they were doing. The restoration of order that their work produced was, in their understanding, a consequence of having correctly identified and successfully prosecuted the person responsible for the original harm. They were not, in their own account of their actions, substituting order for truth. They were producing order through truth. The logic that someone in prison equals a solved case is not a cynical logic. It is an institutional logic, one that follows with a kind of procedural coherence from the design of systems that measure their success by the outputs they produce. An investigation that results in a conviction has, by the metrics available to the institutions involved, succeeded. An investigation that remains open, or that produces a charge that does not result in conviction, has not succeeded in the same measure. The metrics do not capture the distinction between a conviction that accurately reflects what occurred and a conviction that reflects the operational momentum of a case that needed to conclude. From the outside, they look the same. In the institutional record, they are recorded the same way. The procedural steps that carried the case from arrest to imprisonment were, individually, the steps that the system requires. The bail determination, the preliminary hearings, the discovery process, the pre-trial motions, the trial itself, the sentencing proceeding, each was conducted according to the applicable rules by people with the relevant authority, within the time frames that the procedures specify. The defendant had counsel. The counsel raised the arguments the record supported. The arguments were considered and ruled upon. The process was, by the formal standards applicable to it, adequate. Adequacy in procedural terms means that the rules were followed. It does not mean that the rules as followed were sufficient to catch the specific category of error that had accumulated in this case. The error produced not by any violation of the rules, but by the way the rules, operating normally, had processed a hypothesis that had never been adequately tested against the alternatives the evidence contained. The person who entered the correctional facility on the day the sentence was imposed carried with them, into that institution, the full weight of what the system had produced: a conviction that certified their guilt, a sentence that quantified the consequence, and a status, convicted, imprisoned, administratively processed, that would govern every subsequent interaction with every institution they would encounter for the duration of the term and beyond. The file said the case was solved. The agencies that had worked it for 14 months had their closure. The community had its answer. The officials had their outcome. And in the cell, on the first night and on every subsequent night, the question that the system had declared answered remained, for the person required to live inside the answer, entirely open. The case was closed. The truth was not inside it. And the distance between those two facts, unmarked, unacknowledged, structurally guaranteed to persist, was now being measured in the only unit available to the person serving the sentence: days. Closure is an institutional concept. It describes the condition of a case file, not the condition of a person. When investigators and administrators and officials speak of closure, when they use that word in the context of a resolved investigation, a filed charge, a secured conviction, they are describing a bureaucratic state, the state of a matter that has been processed through the available procedures and has reached its designated end point. The file is closed. The resources have been reallocated. The case number no longer appears on the list of open investigations requiring active attention. For the person inside the sentence that the closed file produced, closure is not available. It is not a condition that the correctional system administers, not a status that the post-conviction process confers, not something that the passage of time inside the institution generates. What the passage of time generates inside the institution is more time, each day structurally identical to the preceding one, each administrative interaction governed by the same file, the same finding, the same certified answer to a question that, from the inside, was never correctly asked. The gap between the institutional meaning of closure and its human meaning is not incidental to this account. It is the account. It is what the title names and what every preceding section has been moving toward. The recognition that the goal the system pursued, the closure of a case that had been open too long, that had consumed too many resources, that had accumulated too much institutional and public pressure to remain unresolved, was achieved at a cost that the system's metrics were not designed to measure and its procedures were not designed to acknowledge. The psychological consequences of long-term imprisonment under wrongful conviction have been documented across a substantial body of clinical and empirical research. What that research consistently finds is a profile of harm that is both broader and more durable than the public understanding of imprisonment typically captures. The harm is not only the deprivation of liberty, though that deprivation is serious and its effects compound over time. It is the specific harm produced by the combination of confinement and misattribution, by the condition of being held, officially and irrevocably, responsible for something one did not do, in an institution whose every procedure confirms and reconfirms that responsibility as the operative fact of one's existence. The clinical literature describes the effects of this condition in terms that are precise without being dramatic. Chronic hypervigilance, produced by the sustained requirement of navigating an institutional environment in which the official account of one's identity is both false and unchallengeable. Erosion of self-efficacy, produced by years of administrative processing in which one's own account of events carries no institutional weight. Anticipatory defeat, the learned expectation, developed across repeated unsuccessful engagements with post-conviction review processes, that effort will not produce change. These are not acute symptoms. They are the slow, cumulative deposits of years, lived inside a determination that the system will not revise and the person cannot escape. Social damage accumulates in parallel. The relationships that existed before imprisonment are not preserved in suspension during the sentence. They are conducted, to whatever extent they are conducted at all, under conditions that alter them permanently, across the constrained communication channels of the correctional system, through visiting procedures that impose their own forms of distance and formality, within the knowledge, shared by all parties, that the ordinary reciprocity of adult relationships is not available. Children grow without a parent's daily presence. Partners make the adaptations that extended absence requires. Parents age, and in some cases, die. The ordinary biographical continuity that connects one phase of adult life to the next is severed, and the severance is not repaired by the eventual termination of the sentence. When doubts about a closed case re-emerge, when new information surfaces, when analytical re-examination of the existing record produces findings inconsistent with the original determination, when the questions that were set aside during the investigation are raised again by people outside the institutional machinery, the response of the relevant institutions follows a pattern that is consistent across jurisdictions and case types. The pattern is not one of suppression, it is one of threshold. The institutions that closed the case apply to the emerging doubts the same standards they apply to all post-conviction claims. The requirement that new evidence be genuinely new, that it meet the applicable legal definition of materiality, that it be capable of producing, in the assessment of the reviewing body, a different outcome if presented to a finder of fact. These are real standards with real justifications. They exist to prevent the perpetual relitigation of settled matters, to protect the integrity of final judgments, to ensure that the post-conviction process is not used to circumvent the ordinary rules governing the presentation of evidence at trial. They also exist, in their operational effect, to protect the institutions that produce the original finding from the consequences of its revision. This is not their stated purpose. It is their functional consequence, the consequence that follows inevitably from applying conservative standards to claims that, if accepted, would require those institutions to acknowledge that their ordinary functioning had produced a serious harm. The conservatism is professionally defensible at each individual application. Its aggregate effect across the population of cases where the original finding was produced by institutional failure rather than identifiable misconduct is to make correction systematically more difficult than the original error. The language in which reconsideration is denied draws consistently from the vocabulary of finality. The matter has been adjudicated. The claims were raised and addressed at trial. The appellate process has been exhausted. The standards for post-conviction relief have not been met. Each of these statements may be technically accurate. Each performs, in addition to its technical function, a communicative function. It signals that the institution has considered the request for reconsideration and has determined that the determination will stand. The language of finality does not engage with the substance of the doubt. It addresses the doubt's procedural status, its position in the sequence of available remedies, and finds it insufficient. For the person whose life is organized around the determination that this language protects, the distinction between procedural insufficiency and substantive wrongness is not abstract. It is the organizing fact of their situation. The system is not saying the determination was correct. It is saying the determination is final. Those are different claims. The system treats them as equivalent. The person living inside the determination cannot. The investigation that needed an end found one. It found an end in the arrest, and confirmation of that end in the conviction, and administration of that end in the sentence being served. The institutional need that drove the case toward resolution, the accumulated pressure of 14 months of open inquiry, the expectation of oversight bodies and public audiences, the professional and political costs of continued uncertainty, was met. The pressure dissipated, the file closed, the metrics recorded a success. What the metrics did not record, because they were not designed to record it, was the human content of the closure they measured. The person who had been processed through the system as the resolution of its problem was not, after the processing, a closed matter. They were a person, in a cell, in an institution, in a condition produced by the system's need to finish what it had started, regardless of whether what it had finished was true. The cost of closure is not carried by the institutions that achieved it. It is carried by the person who became the means of achieving it, whose imprisonment was, in the operational logic of the system, the proof that the investigation had succeeded, and whose continued imprisonment was, in that same logic, the ongoing confirmation that the success was real. Closure, as this account has traced it from investigation through conviction to sentence, is a goal that systems pursue for reasons that are, within the system's own framework, entirely rational. It resolves institutional pressure. It satisfies public expectation. It certifies professional investment. It restores the appearance of order. What it does not do, what it was never designed to do, what the system has no procedure for doing, is ensure that the order it restores corresponds to what actually occurred. The case needed an end. It found one. The end was not the truth. And the truth, unlocated and unacknowledged, remains the permanent cost of the closure that was chosen in its place.